This is the March 3rd, 2020 Planning Board meeting. The first item on the agenda is to introduce the Planning Board members. So I will do that down at the end to my right. Brad Harriman, who is the representative from the Board of Selectmen. Next to Brad, John Thurston, then Mike Hodder. To my left, Peter Goodwin and Susan Replier. So we have we have three public hearings. Let me quickly go over the process that we go through. I'll read the item into the record. The applicant then has an opportunity to present the application and answer any questions that the planning board members might have. Matt Sullivan, our planning director, sorry, Matt, I forgot to introduce you. He may or may not add some information that would be important for us to consider. Once we've had the presentation, the planning board needs to determine if first of all, if there are any waivers requested. If there are, we would need to vote on those. And then we need to determine if the application is complete. And so at that point in time, I'll ask for someone to make a motion that the application is complete, and we would take a vote on that, and then I will open the public hearing. And at that point in time, that's the opportunity for any member of the public that wants to speak on an item to address the planning board. Once we've had all of the input from members of the public and the applicant, will then determine if we have enough information, close the public hearing, and in most instances, the planning board will make a decision this evening. So the first item on the agenda was continued from February 11th. This is a two-lot subdivision, the Wolfeboro Bible Fellowship at 533 Center Street, tax map 148-15. So, applicant.
Good evening.
Good evening.
Randy Tatro, Norway Plains, land surveyor for the applicant. We continued, we've gone to a pre-application meeting with the town. We've gone to a technical review meeting with the town. And we continued last month's meeting so that the applicant's counsel could attend the meeting. This is a proposed two-lot subdivision. I passed out some colored pictures that expand the area so everybody knows where it is. It's for the Wolfeboro Bible Fellowship lot. It's an existing 12-acre lot, 12-acre plus acre lot. It's bordered by Route 28 and Kenny Shore Road. The applicant is proposing to subdivide this basically in half, 6 acres and change on both sides. The side to on the town side is existing church that's fully developed, existing state-approved septic system and well, et cetera, and entrance onto Route 28. I want to say,
Sorry.
I want to say that was done in the early 2000s. So, as referenced in my narrative, this particular subdivision is not required to obtain state subdivision approval through DES because it's over 5 acres in size. However, the town's requirements for wetland delineation, soils, topography, et cetera, test bed information, we have performed on the lot that is vacant. The existing lot, we have topography, wetlands delineation, and we show the existing features of that lot, i.e. the buildings, parking, septic system, et cetera. And that would be on the second sheet that has the site feature details. Currently, the proposed lot is vacant woodland. This lot is 200 acres of has 4.9 acres of upland out of the 6 acres, 4.95. It's Group 2 soil, so the uplands is moderately well drained. Considering both lots are in excess of 5 acres, like I said originally, neither lot needs state subdivision approval. They would need on-lot wells and septic systems, thus the need for the test pit, 4K area, and topography and site features. That's pretty much it. It's a standard subdivision. The proposed lot is, the application before you is proposing for this lot to take its access off of Kenny Shore Road. It's being proposed for a single-family site. The lot has a required frontage in the zone, required soils, loading. There really isn't anything in particular to that. The lot does legally have a state curb cut per rule based on the number of curb cuts that are allowed on that lot. So technically, the cutoff date for those kind of things for the state is July 1971. So if you want to understand that, whatever your lot looked like in July, I forget the day, 1971, and whatever you had for frontage then, when the state took jurisdiction, when DOT took jurisdiction over these things, if you had 500 feet or more, you get 3 numbered curb cuts. If you had 500 feet or less, if you had less than 500 feet, you only get 2. So that's why the state makes you provide that information when you go for these things. Now, that's notwithstanding still having to do construction drawings and safe site distance and anything that you would normally do based on what type of entrance you were getting off the highway, i.e. whether it was residential, commercial, or what the use was. So everybody understand that part? So at this point, I think I've outlined what we have proposed to the board as far as application completeness and so forth. I'll entertain any questions from board members as far as the plans, and I can page through the sheets accordingly.
Okay, questions from board members?
Just curiosity, there is the line dividing the lots is at a rather large angle. Why wasn't it sort of perpendicular to the main road?
That's a good question, Peter. I think it was preference of the applicant. We wanted to somewhat split it at 6 acres, and so that was the line that we ended up doing. It was pretty close to 6 acres. There really wasn't any more forethought than that into it.
Okay, Mike, did you have a question?
Randy, would you discuss access to the lot? Where do you propose to run access from? And the state of any permit applications you may have made?
Okay, well, we haven't made an actual state permit application for access off 28 because we're not proposing to come off of there.
You're not proposing to come off
No.
of that? Okay.
Could we? Could make an application to come off of there. We'd have to do construction drawings. In this particular case, given the topography and the impact that it would cause on the lot was much greater, and the applicant didn't want to go that route.
But it is an option?
It's an option.
Okay, thank you.
Randy, if that were to be an option, where would it be? Would it be the area closest to Kenny Shores?
Should I take this off?
Yeah, if you could, Randy, that'd be good.
Okay. Well, I'll turn it around so everybody can see it. So if there were an occasion to try to get an access off Route 28, And you can see what the lots look like. That's just the flat plan, the boundary plan. But if you look at the topography plan, the area that would be probably the best fit would be up in the area by the boundary line. That gives you the best sight distance in both directions. That's also the furthest from any other entrance. But you'd have to take it down, you'd have to go parallel along the contour to get down to the building site. So obviously you guys can see how much of an impact that would be versus where they'd like to come in.
Okay, well, I was concerned about that because I wasn't sure you could meet the buffer requirements.
Right, and if you look at the plan, there's enough room to get through between the right-of-way line and the 30-foot buffer to the wetlands, Kathy, right in this area.
Okay.
You see that? Because at this scale, 1 inch equals 60 feet. You probably got about 40, 45 feet in there.
Okay.
So, yeah, I mean, you could get through there, and it wouldn't be the best situation, and you'd have to, but I think you could avoid a special use permit if you had to. But until you
Okay,
actually...
Well, my concern is that you have to, because I don't think we have the authority to grant any type of a special use on a new lot.
Right.
So I think we have to consider it.
Right, so like I say, there's room to do that there, and again, it's a residential driveway, so it's not like it's a road. You know, so there should be, if it's a regular 12-foot driveway in there, you should be able to get it through there, no problem. But again, the key to that would be to design the approach to the highway. You know, you'd have to design the approach, you'd have to make sure that you could meet that, and then you'd have to grade it off and get around this. So obviously, that's what the applicant is trying to avoid.
Right. There,
Yep.
Yeah, I guess Matt could comment on this, but there was, I read about the 6% slope for driveways, and I wasn't sure that that could be achieved.
Yeah, so we have a 6% grade requirement within the road construction regulations for the town. And basically the way those road construction regulations fit in is that they are the planning board's authority for subdivision applications when it comes to new road construction. There's also a comment in there, though, that any driveways connecting to subdivision roads are required to be, basically cannot exceed 6% in grade for any point for a vehicle width. To be quite frank, I'm not sure that that criteria has been really used in applications in the past, but standard does exist. I struggle with how exactly to implement it on residential driveways, but the standard is in there nonetheless. So it's something that the board may use as a guiding principle, if you will, for driveways of this sort.
Okay, thank you.
Want me to speak to that, Kathy? Sure. The only part that would be in the steep slope category in the ordinance would be this general area right in here, which is obviously guardrailed, so that wouldn't be the area. This is a B slope, which is 0 to 8%. So you'd have to run perpendicular to the contour to make sure you don't meet, you know, an overly excessive I mean, road regs at 6% or 8% are one thing. Residential driveways for one single family unit are usually not held to 6%, but even so, I think you could probably get that in this area right here, running parallel with the contour.
Okay, thank you.
Yep.
One of the odd inconsistencies, just for the record, is that the road construction regulations actually allow for more grade on the roadway itself than the residential driveway, which doesn't really make sense to me. So I'm just not sure that those regulations necessarily work with each other as they exist today.
Okay. Okay, other questions? Randy, did you have anything else you wanted to mention at this point in time? Okay, Matt?
I got one.
Sorry, John.
The volume of the water that comes across that road at that culvert, is it substantial that you're going to have to make some adjustments when it gets to the road that is going to traverse across there?
Yeah, if there were a driveway put in there, John, you know, to go through there, they'd have to have a culvert in there, even though it's not a jurisdictional permit situation. They definitely want to have a culvert, you know, underneath the driveway if they were forced to go that route. But again, it wouldn't be a special use permit or a jurisdictional permit.
Okay, did you have something else, Peter?
Isn't the access off Kenny Road much more logical way to get to that property?
Well, I'm the fact finder in the mission, Peter, but I would say yes. I mean, but I think the owners or the owners' representatives did have a conversation with DOT about that, and DOT would obviously rather see them come in there without, having to do another entrance in the area. They're legally able to apply for one and get one if they meet the rules, but obviously, if they don't have to, DOT would rather they have the least amount of entrances. They always are like that.
Okay,
If that answers your question, Peter. Yeah.
okay.
Randy, from a technical perspective, could you just describe the boundary along or near Kenny Shore Road as you've shown it on this survey plan?
Yeah, well, I will describe it as me and the fact finder's mission. And once it's open to the public and there's any debate on that, I don't want to litigate something that I'm not qualified to do in front of the planning board, nor do I think this is the proper forum to do it, but I can certainly outline why I did the property line.
Just where it's shown, not necessarily even why yet, but where is it shown right now?
Yeah, so historically, 30 years ago when I was a younger man, I did a survey for Wolfeboro Church that was a predecessor to Kingswood Youth Association. It was back in 1989. And during the course of that survey, I had to make a determination on the property line on this side of that lot. So generally, when there is a deed that goes by the road, along the side of the road, bounded by the road, and so forth, unless there's an express language to the contrary, where it would render a different owner in the fee title of that road, then the presumption of law that the surveyors have to go by is that the title extends to the center line thereof. When I came to having to do this one, I looked back at my information, and I was actually quite pleased with, I drilled down on it some more and checked everything that I could, and I felt that I made the correct decision back then, and I still do, which is that both sides, even though it calls for the road, both sides of the road, the property line is actually the center. Subject to all rights away over that land. And in this case, there's a 20-foot right to pass and repass that originally came out from the Kennys back, I believe, in the 30s, originally came out to pass and repass over 20 feet of land. So in this case, the presumption of law goes that there was the original conveyor didn't mean to leave 20-foot strip of land, which is the same presumption that's done in 90% of the streets that we deal with. Normally, we'll show the property line to the stone wall or to the edge of the road, even though the presumption is that they'd own to the center should that be abandoned or any such thing like that. So in this case, the woman that sold both sides did not retain, by language, the fee title in that strip. At least there's no recorded documents that I can use to determine that. So in a nutshell, I feel that this is the property line. And since my name's in the little square, that's the determination that I have to stick with until there's a different conveyance amongst the parties or someone in a road makes a different decision. So hopefully that, is there any questions on how that would be?
Okay,
No.
so we're reasonably clear.
Yeah, it's a different scenario, just to outline it. My dad owns a piece of land in Middleton. He owns 50 feet private road. He owns the fee in the road, and it's attached to his lot at the end of it. So he owns the actual 50 feet, and it's attached to a piece of land. In this case, you have a grantor that sells out on both sides of the road, subject to a right to pass. So I have to put the property line where the abut is attached, even though it says by the road, along the road, whatever it is. It's not an unusual situation, and obviously it can be argued about or refuted, but in this case, I'm pretty confident with my line. Thank you.
Okay.
So does the owner of the new proposed lot have the right to pass also?
Well, that would be more of a legal issue. Again, the presumption that we always go by, and I will defer to the attorney on that, and Randy can speak to that, but the presumption that as surveyors that we use, unless it's expressly outlined that you can't use it, like it was by Mildred Beach on the Kenny Road side. So obviously, if she restricted the access, that means she had access to begin with. So did Mr. Irons, who owned this other side. It wasn't restricted on that side, nor was there any language that said otherwise. And just because they haven't used it for a long time, anytime that you abut a road, it's a presumption of law that you have access from it. So in this case, my opinion, I can offer you my opinion, John. but
Well, you
it's-
have a notation on the second map that says proposed driveway right
Yep.
there.
Yeah.
Yeah,
So you technically have two potential locations to driveway onto this lot. He's talking up off of 28, you're talking up off on the top, and you're talking off to the side of Kenny Road.
right. You're talking, this entrance up in here the state wouldn't allow because it would be too close to Kenny Shore Road. You know, obviously the state's going to look at that and say, we're not letting you put another entrance here. Come off of the road that's there.
I understand. I'm just trying to look at the safety factor here. It makes a lot of safety sense to have access down off of Kenny Shore Road than it does to come off of Center Street in my mind.
Also, disruption of the subject lot if they were to come off of 28.
It would be more difficult to come out of 28 than it would be to come off of Kenny Shore Road, but it is possible to come off of 28. Your wrinkles here and there, but it is nonetheless theoretically possible to come off of 28.
It wasn't thoroughly vetted because that wasn't the route that the applicants wanted.
There is one access route onto this lot, which with some applications and some consultations can be affected off of 28. And then there's the access off of Kenny Shore Road, which apparently is in dispute.
Right. So again, that's the surveyor view on it.
Okay.
Mr. Walker is here to offer any questions on the legal view if the board feels that's necessary.
Okay, thank
Thank
you. Did you want to say anything at this point? Okay. Oh, okay, all right. No waivers have been requested for this application, and all of the required documents have been submitted, so I'd entertain a motion to accept the application as complete.
So moved.
Okay, thank you. Motion has been made. Second. And seconded. All in favor, please say aye. Aye. Opposed? Okay, so thank you. So at this point in time, I'll open the public hearing on this item, and anyone that wants to speak to the issues, come on up and tell us who you are and your comments.
Good evening. For the record, I'm Roger Murray, and I'm here this evening representing the property owners on Lake Wentworth who derive the access to their properties over Kenny Shore Road. I mean, their position really, quite simply, is they are opposed to Kenny Shore Road being used as an access to the present church property or to the proposed lot. This evening is the first time we've heard an explanation about how there might be an access from Route 28 onto the proposed lot. Obviously, the purpose of frontage is to ensure that there is access for fire, police, the property owner, emergency vehicles. And that is why when you're subdividing land, you need to have frontage on a Class 5 road or better, approved on a subdivision plan, going to be brought up to town standards, but basically you need a Class 5 road in order to provide the frontage. In this case, the frontage may not actually provide the access, or at least it's proposed that it's not going to be the access. And certainly it's our position that if you were going to subdivide it, there needs to be established that there is in fact access from Route 28 by way of a DOT permit. That, you know, you can't just kind of fudge it and say, well, we'll just go over here. So I think that should be a requirement before any improvement, any approval takes place. We also oppose the subdivision using Kenny Shore Road because we do not believe that they have any legal right to do so.
Roger, may I say that it would have been nice to have received this yesterday. It's sort of tough to analyze this while you're speaking and while we're supposed to be deliberating on the case, and this, I presume, is an exhibit that is important to your case.
It is, but I think what I have to say is really quite brief in terms
The
of...
documents are not.
Well, there's certain parts of the documents that are
I would
the
just,
really pertinent part.
I'd just like to register, I'd like to have this sort of information before the hearing night, as opposed to the time thereof. Thank you, Madam Chairman. I'm
Okay.
sorry.
The, excuse me, the church's parcel, along with where the youth center is now, is part of a larger parcel that came out of the Kenny farm. The Kennys conveyed that parcel with both the youth center and the church to a woman by the name of Harriet Knight, who became Harriet Hawes in 1935. She conveyed on January 31st, 1962, what is now the church's parcel to V. Earl Ines. And that deed contains the description beginning at a bound on the easterly side of the new location of Route 28 and on the south side of the Kenny Camp Road, so-called, at its intersection with the said Route 28, thence running easterly by the south line of said Kenny Shore Road. And I can say that, you know, we basically agree with the position that Randy Walker has taken in his discussions with me, and also with the explanation that Randy Tetro made to the board. There's one of the cases, and there are many that say basically the same thing. In this case, which is Sheriff v. Morton, it states that we have held that under the firmly established law of this jurisdiction, a conveyance to land bounded by a stream or a highway is presumed to run to the thread of the stream or the center of the highway unless a contrary intention is plainly disclosed. It's our position that this deed, in fact, does evidence a contrary description. It starts on the southerly side, which is the town side of Kenny Shore Road, and it runs specifically along the south side of that road. Kenny Shore Road is not included in that description. At roughly the same time, Harriet Hawes conveyed what became the youth center property to Mildred Beach. And in that deed, it started at Kenny Shore Road and then ran along the road down to the railroad tracks. It simply states that thence running easterly by said Kenny Shore Road to land to Boston and Maine. So it does not address one side or the other of the road. But going back to the Sheriff v. Morton case, that includes language that reads, if a deed by its term conveys to the side of a road, the effect nevertheless is to convey the entire road if the grantor owns the the land under the road and does not own the land on the other side. So this is basically an exception to the usual presumption. And in this case, you have the description of the Irons property as running along the south side of Kenny Shore Road, not including the road, and then you have the conveyance to Mildred Beach. And at that time, Harriet Hawes no longer owned the land on the south side of Kenny Shore Road, but still owned Kenny Shore Road, and therefore that strip of land, the road, was included in the conveyance to Mildred Beach. That also was acknowledged by Mildred Beach in her deed when she conveyed her property to a predecessor entitled to the youth center, which at that time was the Wolfeboro Full Gospel Fellowship, a different church. And in her deed, she states, the second to last paragraph, the grantee understands and agrees that there is not included with said premises a right-of-way over the Kenny Shore Road, but that all entrances and exits to said property must be from State Highway Route 28. And lastly, there is included a survey which was done, I believe, in 2001 by Promised Land Surveying for the church, Wolfeboro Bible Fellowship, which clearly shows the boundary running along the southerly side or the town side of Kenny Shore Road, in which we believe correctly locates the boundary of the church's property. In the deed to Irons, there was no conveyance of a right-of-way over Kenny Shore Road, nor do we believe there was any ownership interest conveyed. And thus, it's our position that the church has no right to use Kenny Shore Road for access to its property or for any other purpose for that matter. The right-of-way that was granted and is referenced on the plan back in, I think, 1930-something, that went solely to the lot owners on the shore. It did not include either of what became the beach or the Irons properties. So we believe there is no access to the property over Kenny Shore Road, and I'd be happy to answer any questions.
Okay, thank you. Question? Go ahead, Peter.
I understand from what it says here, the grantee understands and agrees that that there is a legal basis for this. My question is, why is it a problem to have access off Kenny Shore Road to that property? And this may be a dumb question, but I just don't understand why it's an issue.
Well, my clients do not want there to be such access. I think they're concerned. They certainly can elaborate. We've got quite a number of them here. They can elaborate on that. I think they're concerned about the location of the driveway. They've had repair and maintenance issues in the past. They see this as, a potential problem down the road.
There's also an alternate solution for a driveway, but it's one of those things, I don't understand why it's such a problem to have another driveway off that road. And maybe the people can explain that.
I'd be happy to address some of the concerns of the residents of Kenny Shore. I'm Carl Crossley, and I live at 5 North Kenny Shore, and my family has been a resident on that road and that property since 1973, 1974. Maybe a couple of things that are not technical that either Randy or Roger would bring up is we can't ask V. Earl Irons what he understood. But Mildred Beach, because V. Earl Irons was born in 1895, he died in 1992, 1993 at age 95. I have spoken with Mildred Beach, and she was quite clear that this so-called sale was really Harriet Hawes paying off a debt. So it probably was a $1 sale to Mr. Irons, and he wanted no part of the road, no responsibility, no liability for the road. And so, and that's why that deed was written so explicitly south side 3 times separately. I'm not answering your question yet, Peter, I recognize that. And that's why Mildred felt entitled to think that she owned the road when she did not allow the Wolfeboro Full Gospel Fellowship to have access or use of the road. Obviously, she had some self-interest in that because she is one of the property owners on Kenny Shore as well. When the church applied for the variance to create itself, then Pastor Scott Button wrote to Judy O'Keefe on the shore very collegially, saying they wanted to be a good abutter and a good and to let them know what was going on. And he wrote a detailed letter on February 5th, 1991. On July 16th, 1991, the ZBA held the variance, and at the variance approval, the minutes include a statement that the access for the church will be off Route 28, which it is. What is not in the minutes, but is in notes that we have that were recorded, is that Mr. Button specifically acknowledged that they had no access over Kenny Shore Road and were not going to use Kenny Shore Road. That was the minister of this church at that time.
I think that this has been described very well by Roger, and I just am interested in why it's a problem to have another driveway on it. And you haven't answered that question.
I apologize. I mean, I do intend to get to that. I mean, the church has always been good neighbors to us, and we've never had any difficulties, and we have no sense of bad intentions here. Our concern is for the present in terms of maintenance of the road and construction and putting a driveway at the one point where we've had significant issues with slope that would create a significant hazard. In addition, there has been significant movement on this town's part to rezone that part of Center Street. And we have significant concerns down the road that other than this becoming a rural residential, but there has been movement to move that into a special area for commercial property. To move any kind of commercial stuff on that road would be destructive to the road and to the access of the owners. So there's a current concern as to the use of the road, and particularly since of the slope at which they're positioning that driveway, and the long-term concern because of potential zoning changes that this town has been interested in for a long time. In the 30-some-odd years that my family has been part of that road, we have maintained that road, and we have put significant resources into it. None of the prior owners, neither Mr. Irons, or Sonic Foods, which I think is actually Mr. Irons' company, or Carl Godell, claimed any use or access via that property. And the church, when it first came in under existence, did not claim any entrance. As a matter of fact, acknowledged that they had no access via Kenny Shore. They've changed now. Because Mr. Tetro has inadvertently created a boundary line by his interpretation, doesn't change the way things should be. We don't own the property. We understand that. We have right of way. The youth center property is the owner, and as Roger has explained to you, and therefore we can't grant access or not grant access, but we don't think anybody else should either because of who owns the property. Is there anybody else who wants to say something?
Yeah. Thank you.
Peter, does that answer your question at least in part?
Yes, thank you.
Hey, Mr. Walker.
Peter, I'll answer your question. There's 20 people that are using that road. I'm just making up a number, but a couple of dozen, and we're trying to add one more. We don't think it's a problem at all. Another point that I want to bring up that I sort of thought as everyone was talking, and that is the Kingswood Youth Center, according to Roger, owns the road, and they're not objecting to this. We have people on the other side of the tracks that are objecting, but not the youth center itself. So if you agree with their position that they own the road, the owner of the road is not objecting to this. We believe, and Randy has shown on his plan, that the property line runs right down the middle. This board has approved 3 plans that show it running right down the middle. In 1989, when the Kingswood Youth Center property was subdivided off, it showed the center line. I have the plans with you if you'd like, but I'm a little hesitant to bring them up because I didn't bring them a day early. Didn't even get a smile at a mic on that. 2, there was another plan that was approved in 2009 when the youth center subdivided off a piece on the other side, on the I'll say the 7-Eleven side of the property. And then in 2016, they did another subdivision. And again, this board approved all 3 of those, showing the line running down the middle of Kenny Shore Road with no objection from any of the abutters that are now here today. So this is the 4th time that a plan has shown the property line running down the middle. And this really isn't all that complicated. It's a 1-lot subdivision, a 2-lot subdivision. They have 6 acres. They've got over 500 feet on Route 28, more than that on Kenny Shore Road. And I think that the law is fairly clear and has been since 1873 that if property abuts a road and it isn't clear that the person conveying the road retained it, then you own to the center of the road. And when the youth center property came out, they got everything on the north side. And when the church property came out, they got everything on the southern side. And the road strip was left in between. And since 1873, the law has been if you leave a strip, both sides get it equally. It's been very clear that that's the law, unless something in the deed says that is not the case. The deeds that Roger gave you, which we've looked at, I know them by heart, don't say that there was any exception to that rule. Their property, the youth center owns everything on the north, the church owns everything on the south. And in that case, it goes up the center line, which is what Randy Tetro has shown now 4 times, 1989, 2009, 2016, and now 2020. There's also a presumption that if you own on the edge of a road, you have the right to use the road. And the clear, logical access to the church property or this subdivided off lot is to come down Kenny Shore Road and not come off Route 28. There's no good reason for it to come off 28 if you're just the average person in town. The logical place is to come down Kenny Shore Road. There's less traffic, safer, smarter, more logical, shorter, aren't skirting wetlands. There's 101 reasons why the best access is off of Kenny Shore Road. So to me, the law is clear. I won't get into the legalities, although I'm happy to grapple with that. But bottom line, the people that allegedly own the road aren't even objecting to it. It's non-owners that are objecting. And I'd be happy to answer any questions. I see, Peter, you have one.
If the idea is that lots of abutting roads go and have access to the road, if you go down to Kenny Shore, how are those properties different or similar to this particular issue? Here we have a road which goes down with a right-of-way to Kenny Shore, and then you end up having a bunch of houses off of Kenny Shore Road. Do they have the same kind of access? I mean, apparently they do.
Yeah, my belief, without looking at them, is that they do. I'm specifically talking about the property between Route 28 and the railroad tracks. That section of Kenny Shore Road, my belief, the Wolfeboro Bible Church owns the southern half, and the youth center owns the northern half, which, again, Randy has shown on the plan and shown on 3 plans which this board has shown. What happens on the other side of the tracks, I didn't look at that particularly, but that's not an issue because we're not trying to obtain access off that. We're just trying to obtain it off the upper section, on that side of the tracks.
If Kingswood Youth Center owns the north side of the road, and it can be argued that they own the entire road, has your client considered getting an easement from them to pass over?
So I contemplated that. You know, you're always trying to spin options if that was the case. But we were so convinced that that was not necessary, we didn't go down that road.
Okay.
Because I think that the law is very clear that you own to the center line, but that potentially would be an option in a worst-case scenario for us. But not one that we are presenting to the board, because we believe we own half, the youth center owns the other half, and that both sides legally could use it, except as Roger did accurately point out, the youth center is prohibited from using that by a deed restriction when they got the property, so they cannot use it. They still own half of it, they can't use the half they own.
If they cannot use it, they can't grant an easement over it, presumably.
Yeah, they're restricted from using Kenny Shore
That
Road
is
by
not
deed.
an option.
Not an option for them.
Okay. Thank you, Ray.
Okay,
And there's no deed restriction for the other side?
None, never were.
okay. Any other questions, folks? Thank you.
I think it's fair to say the reason the youth center isn't concerned about the use of the road is because they have no right to use it. So I can't see why they would particularly care about who's going up and down the road. They don't maintain it, and they can't use it. We believe that the deed is quite clear, that it specifically states that the church's property runs down the southerly or the town side of the road. It's right there in black and white. It's not like something got left out or misplaced or anything else. It was not conveyed to Mr. Irons when he acquired the property. While it is true that there are a couple of subdivision plans that were prepared for the youth center, I think there are two plans that actually show the location as being down the middle of Kenny Shore Road. Several of the other plans don't show Kenny Shore Road at all. As has been pointed out, the youth center can't grant an easement over the road because they're prohibited by the deed restriction. You know, while it may be logical to come in off Kenny Shore Road, just because it's logical, if you don't have the right to use it, you can't come in that way. There are many things that may seem logical, but if you want to use something as a driveway or an access, you have to have the right to use it, and in this case, the church does not.
Roger, is there an issue if there is an alternate way to get to the property off of 28 coming down as described here in the plan? Is there an issue, or are you opposed to a subdivision if that is a legitimate way to get to the property?
No.
So therefore, there is really no reason to oppose this subdivision.
Well, if it does not have access, there's a reason to it.
But if you can come off 28, there is access.
There is access.
But
Therefore,
there needs
this
to
is-
be a demonstrated access. I mean, until we got here tonight, there was no driveway proposed. It was not mentioned in the application. This is the first time we heard about it.
But if that isn't a legitimate access, is there any reason not to allow this to go through?
As long as obtaining the DOT permit is a condition of the approval, we'd have no problem with it.
Okay, thank you.
Okay, go ahead. Go.
All due respect to everybody, and I hate that term, obviously, I know this whole situation by heart, just like Roger does, and I respectfully disagree with his interpretation, although he's certainly entitled to it. And if you look at the original outsales to these deeds, the outsale of Harriet Hawes to Mildred Beach doesn't have an instrument date, and it's recorded 2/12/1962. As a constructive notice state, we always go by the instrument dates, and then if they match, like in this case, they're real close, we look at the recording dates. So the deed from Harriet Hawes on 1/31/1960, on from Harriet Hawes to Irons, 1/31/1962, was recorded 2 days after. So in this particular case, it's pretty close to the same time. So those two pieces were deeded out generally at the same time on February 12th. It got recorded at a different date, but generally, what I want the board to understand is both of those pieces came out at the same time. And so the theory that because Mildred Beach's got recorded a couple days differently, that somehow she gains title to a strip of land instead of the other person is just not something I can go on. All she had to do at the time, if what they're saying is true, is to get a quitclaim deed from Mr. Irons, a quitclaim deed from Mrs. Hawes, and then we would have put the lines where they're thinking they are. And in this particular case, I can't do that for those reasons. And I just wanted to clarify that.
Thank you, Randy.
Okay, thank you.
What Randy's just said is simply not correct, except in terms of the recording information. The deed to Irons is dated January 31st, 1962. The deed to Mildred Beach was not dated, but the acknowledgement was February 15th. So Harriet Hawes had conveyed to Irons when she conveyed to Mildred Beach. Therefore, she did not own the Irons piece at the time of the deed to Mildred Beach.
While this is a fascinating issue,
Yeah, okay. Any other comments? Okay, go ahead, Matt.
well, this is a fascinating issue. Obviously, the board's jurisdiction is deciding whether or not this development lot meets the criteria of the subdivision regulations.
Right.
And I hate to push the issue along, but if the board is not comfortable that the lot proposed has access, whether it be on Kenny Shore Road or on Route 28, I think that they should make a specific ask to the applicant for a driveway permit or something to that effect. If the board feels that access has properly been demonstrated within the application, I would be cautious about making any kind of determination upon what the actual access is. And I would sort of enunciate that by saying that the board has allowed for driveway cuts to be shown on subdivision applications for many, many years. In no case has an applicant, with the exception of a special use permit, been bound by the subdivision driveway permit that is shown on the plan. That process is handled through the driveway permitting process with the town or with the state of New Hampshire. So although a driveway permit or a driveway cut is shown on this plan, the applicant will ultimately be required to request permission from some entity. I would be cautious about the board making a determination on that this evening.
I think we understand that.
Right, we just, we need to approve lots with an access.
Correct.
And so they're showing an access, but not
Right, and I would just...
necessarily the specific one.
Right, and I had asked the applicant to clarify the likelihood of access off of Route 28, because I think there is, because of this potential legal issue, I think there is a need to certainly demonstrate that. It's really, to what extent does the board require that to be done? Is it with a DOT driveway permit in hand, or are you comfortable with the fact that the applicant would not be able to develop the lot at such time until they're able to obtain legal access?
Well, in subdivisions, we generally have that as a condition, that the driveway permit must be obtained. So if they go to DOT and they cannot get the driveway cut, then they don't have a lot.
There are two ways you can handle that. You can make it a condition precedent or subsequent. That's up to the board. If you feel uncomfortable with the subdivision without the DOT driveway permit, then I think that's fine, and you can also do it the other way as well. Either way, the applicant takes on the risk of potentially creating a lot that has no legal access to it. So it really depends on where you want the risk burden to be, I think. So in the event that it's a condition subsequent to signing of plans, the subdivision could be recorded, but if they're unable to get a DOT driveway permit, they're simply left with a lot that can't be developed.
In the present circumstances.
Yeah.
I think it's in, from my perspective, in order to grant this subdivision, I'd have to make it conditional upon gaining an NHDOT driveway permit off of Route 28 because access off of Kenny is in dispute. I would want the applicant to understand that that would be the condition and have the option of withdrawing the application, thrashing out in one way or another access over Kenny Road, and if successful, coming back and applying for a subdivision with the access the way they would like it to be off of Kenny Road, and if it is not successful, coming back and applying for access off of Route 28. But right now, the only way I think this board could grant this subdivision is with the understanding that it were conditional on approval of an NHDOT driveway permit off of Route 28 with all of the convolutions that are going to be required accordingly.
How does that sound to,
I don't understand why we have to go that route. I think we've got some precedent that we're hearing from Mr. Walker on the lot line. He's given us some case history on that, and I much rather think it's a safer approach. And again, I'm going to weigh the safe factor over the other factor, just because that's my honest feeling. I wouldn't want to see a driveway up on that top. I know what it's like driving on that road, and somebody comes up behind you, and then they go around you, and then they hit the car in the other direction. I was like, the more you can mitigate the potential out there and get people off the side. I mean, I understand that a lot of people don't pay attention when they're driving, and if somebody can get off to the side and then make a slower turn, it's a benefit. I understand the people who make the case for not having passage to go down through there, but I'm trying to weigh all the options, and I would rather proceed with a condition that they access off of County Shore Road.
I would completely agree with you if I could give that kind of approval with certain knowledge that there was legal access off of Kenny Road for that lot. And we have 20-odd folks here represented by a lawyer who claim that that is not the case, and another group of individuals represented by another lawyer who claim that it is the case. We are not judges. We can't adjudicate.
right?
We can't make that determination safely. We made that determination, and I agree with you. Kenny Road is the place to come off of. I know that area just like you do, and that's the safest way to do it. But if we grant permission for the subdivision with access off of Kenny Road, and Mr. Murray and his cohort go to court and successfully show a judge that they do not have legal access down Kenny Road, and the condition, and then
I think it
subdivision approval is null and void.
goes both ways. If they get the approval for out on 28, then they go to court and they fight that they want it on Kenny Shore Road because they have the right. I mean,
That's why-
you fight it both ways. I mean,
That's why I
so
suggested to the
the burden's on the owner of the lot who creates the lot, in my view. If they end up with a lot that they can't get to, there's just a lot.
So that's why I suggested that the owner representative might suggest to the owner that they thrash out Kenny Road access, which is the preferred access.
Right.
And the fallback position be the NHDOT and come back again here. Let's
Why do we-
continue this
why do
application.
we-
Well, I mean,
They don't have the right to settle it.
okay, our obligation is to look at safety issues and the general welfare. That's why we have subdivision approvals. And I agree with both of you that I don't think it's a safe access off of 28, and Kenny Shore would be a safe access, and I think that's an important consideration.
I think we have a concern for safe access, but it's really, NHDOT is going to do the line of sight and the traffic study and all the other requirements to be sure that access off of 28 would indeed be safe. We're not qualified to do that absent studies.
Right. Yeah, the other thing that concerns me is that it's going to be very disruptive if the driveway is put off of 28, just disruptive to the land, which is then is part of the Lake Wentworth watershed area. So, I mean, that was another thing that I was concerned about, and it's certainly would be less disruptive if we were to be able to have the access off of Kenny Shore Road, so.
You feel confident that we can grant this subdivision based on access down Kenny Road?
No, not from what we've heard here tonight, but our obligation is to make sure that there is an access, and I think we certainly have had testimony that there's access. Randy has described to us a plan that probably would be nice to see, but that's not one of our requirements.
And again, it is, many of the subdivisions you see, we assume that the driveways shown can be permitted. We don't, I'm not aware of a case where we have asked for the driveway permit to be supplied with the subdivision itself. So Kathy, to your point, I think the applicant has demonstrated that it is possible to obtain an access. It depends how far you'd like to go past that as far as a condition, but
Right.
I think that's
Access
clear.
off of 28.
Yes,
I think they've made that representation this evening.
yeah.
Do we not want to give the applicant the option of withdrawing the application pending resolution of the dispute if they're going to go that direction? And then come back to us with, yes, we have access, or no, we're going to go with DOT?
Could I make a suggestion? And that is, approve the application, approve the subdivision, and we'll then decide whether we come down 28 or Kenny Shore Road. As Matt pointed out, wherever we show it, we have the option of coming in. If we come in off of 28, we get a permit, we come down, then that's the way we come. Let's presume we come in off Kenny Shore Road in 5 years or next year. The group here can object if they would like, and we can litigate it, but it's not in the board's jurisdiction. You know, you don't really need to dictate where the roads are and the driveways are, as Matt suggested.
No, but we have to be able to dictate access. We have to be, at least be able to show that there is access, correct?
Yes.
Correct.
The only access that we can safely show is off of 28.
Well, that's one. And two, you do have a group that doesn't own the road that's objecting on behalf of what they claim to be the owner of that road, which I find a strained argument for the planning board, whether it's legitimate or not, that you don't actually have the owner that's complaining.
I understand.
So again, my suggestion would be, they don't really object to the subdivision. They object to coming in off of Kenny Shore Road. And if we go in for a driveway permit, Matt can flag the file and have Corey or whoever issues the driveway permit say, we have to give Roger Murray notice. We're happy to have him get notice, and if they want to litigate it a year from now, 2 years from now on that point, they can, and we can make that decision. But I don't think we need to hash it out first and withdraw the application. We're here. This is already a second hearing. And I don't think that the criteria other than this aren't met. We've got 6 acres. We've got 500 feet of frontage. There's definite access one way or another. Randy has proven or testified he believes we have that access, which is all you ever require in any subdivision.
Right, well, we have 2 points of access. So in my mind,
The only matter that makes
possible.
me feel uncomfortable is that the application plan shows only one of those 2 points. That one condition of the board could be
yes,
to show a second, a second optimal point of access.
right,
Yes.
Well,
yes.
you already told us the driveway access off of Kenny Road is just hypothetical. It doesn't stand for anything. so
Understood, but I'm just saying, if the
ignoring
board
it.
is uncomfortable, then you certainly could show a second if you feel the need to.
But we don't
Request
really
that.
have a second shown on the plans. We're not requiring one on the plans. We're requiring a DOT application as a condition precedent to approval, correct?
Well, we're saying
subsequent.
that you
Condition
have to have a driveway permit.
Yeah, and we'll get it, and so if we grant the application conditional upon a DOT permit, driveway permit subsequent, then they can, if they want to, thrash it out. Is that what you're suggesting?
No, I'm trying to avoid the DOT application, which I
right.
think is a waste. You don't want it, we don't want it.
How can I grant you, how can we grant you a subdivision approval without showing where you intend to get access to the lot. You have to have access to your lot.
Well,
If I could just address that quickly. So you approved, not this board, but the Embassy Estates subdivision had 48 lots in it, I think, back in 1989. 48 driveways were shown. I bet you not one of those driveways was put where it was shown. The homeowners came in, oh, we'd like to move our house over here or over here. It's just a suggestion. It's a guidance. There's a septic system shown on this plan, too. The owner may not put it there. They may move it 100 feet this way or 100 feet that way. It's just an example of where it is. And Randy has clearly testified he thinks that we can get that. So usually this board leaves it to the applicant to come in, not before this board, but to apply to the Public Works Department or DOT, whoever it is, to get that permit down the road when they determine where they actually want to build the house, put the septic, put the well. It's just a guide. So again, my suggestion would be to approve it, and whenever we come in for a driveway permit, if it's on Kenny Shore Road, that this group can object if they think that it's inappropriate.
I have one question for the applicant. Would they be adverse to contributing to the road maintenance fees on the road?
So I can tell you my advice would be absolutely contribute. I believe the law, however, is clear that if you use a road, you have to pay for it. Period. I think the law was not that way. I don't know how many people I sued in associations that never formed the association, and the law is very clear. If you use, you must pay, and I absolutely would encourage those people to pay 1/21st, whatever those road costs were. That'd be my advice.
Matt, would we be in a better position if we had a plan of a driveway off of 28? I'm concerned that if this is appealed, I want to make sure that we
I actually think the safest option is you have two options. One is to simply show no driveway access and let the record speak for itself.
Well, we already have a driveway access shown.
No, I understand, but you could choose to remove that in the interest of not making a statement. But I think the preferable option is to actually show two accesses and two locations of septic and well to demonstrate that the lot is in fact buildable in two locations, if you feel that's necessary.
Okay, how do you folks feel about that?
I think that's a little too...
I don't feel that's necessary, no.
Okay. Yes, sure. The public hearing is still open. Okay.
My name's Jack Holbrook. I'm one of the neighbors from Kenny Shore.
Okay.
Jack Holbrook. And I wonder, given the suggestion that there may be litigation about this down the road, if the thought that these potential locations, that it's not quite as moot a point where these might be moved to, that it makes sense to actually have two locations as a way to firm up the possibility that there are, in fact, two real locations, potential locations.
We've had testimony for the two locations.
I wonder why that wouldn't be in your best interest, our best interest.
Okay, thank you.
Well, first, I'd just like to note that the Embassy Estates subdivision was probably not a good example because the town got sued and lost its shirt on the roads in there. But be that as it may, once the planning board signs a plan, it's done. It's a subdivision, and you don't really have a good way of clawing it back. And I think the board needs to take that into consideration to make sure that you don't suddenly have this lot. I mean, I can see where there are issues with an approval in getting a building permit for this lot.
So if you have a driveway that's plotted in this subdivision application, and it's approved, and you litigate it, and the judge says, no, you don't have access, then whoever that is, they're going to have to come back to us and get a driveway. No?
No, they would just, in this particular case, they would be forced then to look at an alternative access along the abutting road. Wouldn't have to come back to this board because the driveway location, in my opinion, is not binding. So I don't think they'd have to return to the board to amend the subdivision plan.
Okay, but no building permit can be issued on this lot until there is a driveway permit. A valid.
That's correct, yes, absolutely, yes.
Yeah,
No, I just
okay.
want to make sure I understand the question. Yes, yes,
Yeah.
of course.
Okay,
Yes,
so nothing is going to happen unless they get the driveway permit, then the building permit can be issued.
That's
I'll-
correct.
I'm just trying to, I mean, I think we've got a couple folks here that think that we do not need another plan off of 28. Yeah, but go ahead, Brad.
Yeah, I just wanted to say I had come to the kind of same conclusion that Randy did here as an option, that we can approve this subdivision with a condition. My thought is to show, maybe a conditional that they show an option for a driveway off Route 28, keep an option off of Kenny Shore Road, so they're both on the plans, and then it's up to, the applicant, whenever they decide to come in for a building permit, to figure out which one they want to use. If it ends up being Kenny Shore Road and it has to, they have to do whatever they have to do with litigation if it goes that route or whatever, or they still have that option on 28. That way, we would have to come back to us at all. It could be done as a condition upon approval tonight on this plan, that be shown before it's recorded, and I think we cover all our bases, and I think that would hopefully suffice the folks down on Kenny Shore Road, that they know that there is that option there for Route 28, if that's the way it has to go. So that was my thought on it.
Right, and I'm thinking that we've had the testimony here. The testimony is part of the record. So I'm wondering if we do need a plan of showing a permit, or a curb cut off of 28.
Okay.
So I don't know, are people comfortable with moving ahead like that? Or
If there was a curb cut, the culvert that comes across Route 28 is one that catches a ton of water. It's in that low spot right there at the bottom of the field right there. And it catches all that water on the side of the road. I mean, if you do a curb cut and you have to pass that water by your road, you got a lot of potential erosion going on right there. And they're gonna do, I mean, if I was gonna approve it, I'd want to see it at least to the Kenny Shore side of that culvert. And Randy says he might not, it might be
so
too
you're
close.
saying you'd like to see a plan?
If they would have a plan, I don't want to see it cross that culvert area, for sure.
Okay. Mike, did you
Question
have?
for Matt. Is it safe to approve a subdivision with no access as defined in the application itself? In this case, if they're not sure whether they want to do a Route 28 or a Kenny Shore Road access point, and we're thrashing out, maybe they should show both, or maybe they should show none, or whatever, can this subdivision be approved without access points and just leave it as the chips fall where they lie? If they approve, they go for a building permit, they have to have a driveway cut, and that's either off of Kenny once they figure out what they're doing, or off of Route 28 once they get a permit?
I think it's in the board's best interest to have some sort of driveway cut shown.
Okay.
I really do. And part of that also is that we don't ask for the full driveway to be shown. We're asking only for the access point so we can talk about safety,
Yeah.
traffic impact.
Right.
So I think the cut itself should be shown. But again, I would argue that cut is in no way binding upon the applicant unless the board specifically takes an action to make it so, and I don't think you're doing that here. So
Well,
I would
then-
prefer, Mike, that some access be shown on the plan.
Okay, so the prudent thing would be to hold this over and request that information.
There are two options. You can conditionally approve upon a plan to be revised and shown to the board, or you can continue 2 weeks give the applicant an opportunity to draft a new plan showing a driveway cut along Route 28 that they believe would be permitted. That's one approach as well.
I would suggest that we ask the applicant to continue, or we continue this application, give the applicant and the other individuals a chance to thrash it out and work it out without difficulties, and then come back to us, the applicant come back to us with a new set of plans showing the access point that they would like to have on the...
Okay, go ahead, Roger.
I would just like to point out that I think the board needs to be careful. If you approve in some form this plan and it's recorded in the registry of deeds, and suppose the church doesn't have a buyer, it sits on it 5 years, 10 years down the line, and suddenly comes in and buys it, that's going to be a real problem if it's not clear, because somebody going to a title search and say, oh, look at this, we got an approved lot, nice location, and then you go in for a building permit, and that's a problem, and I don't think it reflects well on the town. So I think you do need to be careful about that.
I think we should continue the hearing.
May I add
Yeah.
one more point? If it's approved just showing the Route 28 access without DOT approval, you then prejudice the DOT to take the path of least resistance and assume Kenny Shore is proper, which is obviously in contention whether it's legal access or not.
Okay, well, I don't think we can require, I mean, we have not done that before. So I don't think that would be unfair to the applicant, I think.
Just in response to that, you do it all the time. I can't think of a subdivision that we have submitted in the last 30 years where we didn't show some driveway, and invariably, they don't get used, they get moved. And the only requirement is that we show a viable driveway. They've done that. This is a one-lot subdivision. This isn't 40 lots. It shows a driveway. Whether the applicant chooses to use that driveway or not, they may or not. And as Brad pointed out, when they come in for the building permit, they're going to have to demonstrate at that point, like everyone else does, whether that's a viable driveway. And we've shown a driveway. Whether you like it or not really isn't critical as long as it's somewhat viable.
If this were the state highway, I'd have no argument with you at all, but you're showing access onto a road, private road, which is in dispute.
So I don't think we'd have any objection if this board was inclined to say, we'll submit as a condition of approval a curb cut, exactly what Randy put on Route 28. We'll just give you, whether we use it or not, that'll be up to us when we come in for a building permit.
That's
But I don't think there's any aversion to showing two. We'll show 10 if you'd like, but we're only going to pick one. And I think we only need to require one. So again, as a condition of approval, we're happy to put one on Route 28 as well.
Isn't the circle drawn next to Kenny Road, which is the driveway, couldn't you literally just draw another circle near 28, which therefore would say, here's another driveway access? And so that's not a complex idea, and neither of them are going to be drawn exactly in those spots.
Correct.
So, all you need to do is say, draw a circle where there's another driveway access as part of the...
Just for clarification, the proposed driveway is actually it's shown as a stub, not the circle. The circle is the well radius, but
Right, yeah.
they should show. I guess that's my only concern, I guess, now about continuing this for a cut to be shown. I'm just not sure what criteria the board will use to evaluate the driveway at that point in time, when in fact, again, that is a non-binding driveway cut that they will show. So I guess I am sensitive to the applicant's point that maybe it should simply be a condition of approval if the case is approved this evening, that they add one to the plan.
Okay. Okay, any other, okay, and then I'm going to close the public hearing.
So
Okay.
it would be easy enough to show a proposed entrance point where I indicated up near the property line. They do have a legal position to be able to, by law, with a number of curb cuts, to have a spot. What we were trying to avoid was designing something because we felt that we had the right to use the road. And so if that was proven to be was determined that we couldn't use it, that we would have another spot up there, and then we would go through the design process, because you have to design that entrance, if the other one was proven that we couldn't use it. So there's no problem with showing a proposed spot up there because they legally have the right to do that. To get the permit is another hurdle to do the design and to get the actual permit. They could do that. The state could say, there's a permit for Kenny Shore Road, use that one, not knowing the whole situation.
Well, they couldn't say there's a permit because there isn't a permit.
Excuse me?
They couldn't say there was a permit to use Kennedy Shore Road because there isn't a permit.
Well, there's a state permit for Kenny Shore Road. There's a state entrance permit for Kenny Shore Road.
But, okay, I see.
You know what I'm saying, Mike?
Yeah,
There's just a legal
Access from
disagreement
this,
on the right to use it. So it would be easy enough to show a proposed state entrance there. I could send a letter saying they've got that they've got the legal right to have a spot there. It's whether or not the board feels that they got to go through the whole DOT permitting process, whether they're going to use it or not. If they were, they're victorious in the decision to be able to use Kenny Shore Road. You follow? So we can show both. Whatever way it turns out, they got one that they can use. If the board wants to go an additional step and actually get a state permit, then that's going to be a little bit of work for the owner to be able to do that, and they may never have to use it. So personally, that's up to the board, but that's my take on it.
So could we get a legal letter from Randy stating he has that there's legal access with a curb cut off Route 28?
Certainly request it.
Until he becomes a judge.
Well, he's stamped. He's backed by his
Oh,
stamp.
you mean this Randy?
Yes.
He could simply say that based on DOT criteria, they are entitled to a driveway cut. I think that's what he's
Yes.
able.
Well, yeah, they
Based on the linear feet
Yeah.
along the road and the permitted amount of driveway cuts.
And that would be conditional and
if we were to approve this without condition, if we were to continue it, require new plan showing 2 driveway cuts, leave the original Kenny Road proposal, and an NHDOT random wherever they want to put it based upon linear footage cut, with no condition to obtain the DOT permit, would that be done without jeopardizing the decision? Basically,
I
Randy's
think it could. I guess my only question would actually be, is there a need to continue based on what you're saying?
no.
Well, in other words, approve it conditional upon new plans.
Yes.
That would be fine. That would be fine. I could go with that.
okay. I'm going to, I don't see any other hands, so I'll close the public hearing. Okay. I guess I'll open the public hearing.
My name's John Sweeney. I live down on Kenny Shore Road. I'd like to request that you do not approve the application at this time, just because there is obviously contention over where the property line really is. And as Randy pointed out, he pointed out case history of the board approving applications on this property in the past, and now we come up that the property line is in dispute. I'm also curious how the property is surveyed down along Kenny Shore Road in a tangent when the original survey was as a straight line, I believe. And it was also said in the deeds that in going back to 1934, that it is a right-of-way for the Kenny Camp residents. As I understand it, a right-of-way is really a virtual magic carpet of access forever for those people to the Kenny Shore camp roads, not to newly created lots sometime in the future. So I think if the board grants permission to this at this time, even with conditions, then it's going to set a precedence. And I think the application should show that access off of Route 28. I don't think any of the residents here have an objection to an access off of Route 28. And to answer Mr. Goodwin's question before of why we would have any objection to a driveway coming in there, Kenny Shore Road is a dirt country lane. It's not a road. It's a right-of-way that the shorefront owners have used. So I can appreciate that this new applicant would like to coattail on an existing road. But if the deeds in their spirit and intention from 1962 said to the south side of the Kenny Shore Road, their intention was that there would not be any split down the middle access. So again, I'm questioning the curvature and the tangent of the plotting, and I think that's based on that rule of 2 lots abutting a road, which state New Hampshire law is gates and bars is a traveled road, a highway, not necessarily a dirt right away. And to have a perpendicular cut going off of that narrow dirt road, and I realize that the legal right of way is 20 feet, but the road is probably more like 12 feet wide that everybody passes on with grass and woods on both sides. And to make a perpendicular cut in would involve a radius, and I can see the road widening in the future. Fire, emergency trucks, delivery trucks, UPS trucks, moving vans. It's inevitable that that road is not going to be in the same character that we've enjoyed it for 100 years.
Okay, thank you. Okay, I'm going to close the public hearing. Board members, I think we have a lot that conforms with our subdivision regulations with some access points. So how would you like to proceed?
Move to approve this within.
Would you like me to review some?
Okay, and
Review some conditions.
yes, I was just going to say, could you please go through some conditions?
So conditions will ultimately be 1 through 7 are my recommendations should the board choose to proceed. Condition 1 is the incorporation of the plans as amended to the date of this approval. Plan number 1 being the subdivision plan, and plan number 2 being the topographic subdivision plan. Condition 2, the applicant shall be responsible for submitting a Mylar plan for recording at the Carroll County Registry of Deeds. Condition 3, the applicant shall be responsible for the payment of all recording fees. Condition 4, all of the documentation submitted within the application package by the applicant is obviously incorporated as part of this approval. Condition 5, the applicant shall be responsible for monumentation and submittal of a certificate of monumentation and updated plans, including original stamps and signatures from a licensed land surveyor and certified wetland scientist. The addition of condition 6, which is the applicant shall provide a revised subdivision plan with proposed driveway access to Route 28 to an area that meets minimum development standards. And then condition 7, the applicant shall provide a letter justifying the proposed lot's qualifications for an NHDOT driveway permit.
Say that again?
Condition 7, the applicant shall provide a letter justifying the proposed lot's qualifications for an NHDOT driveway permit.
Why is that required?
That's what I asked for.
There was a request, I thought I heard a request from the board that the applicant's surveyor of record provide at least a basis for the statement that the lot would be entitled to a driveway permit.
Well, he's got the frontage on 28.
So therefore, the statement is appropriate, it's easy to do.
They have something to fight over.
I'm happy to remove the condition, but I think the record does speak for itself, but I thought the board had requested
You
it.
just have only to look at the plan, and you can see they qualify for an NHDOT driveway cut on that frontage. They have enough frontage. But if John feels more comfortable with it.
What we're trying to alleviate is them to having to go through a design of a plan that reads one particular location. They're trying to take testimony that says he's allowed this based on this amount of footage, and
There's no harm in the inclusion of a
Yeah, I
letter.
don't see any harm to the,
And the DOT standards, until I actually spoke to Randy earlier this week, are not abundantly clear to me sometimes, so I'd prefer to have the justification laid out in a letter.
500 feet.
Depends on the date of the lot. I just would like to see it memorialized in a letter.
okay, are you comfortable with that, John? I am. Brad?
Yep.
Okay, Mike, how are you?
Certainly.
Okay, folks? Okay, and Matt, we don't have to put anything in about my concern about the special use that we will,
No, I think it's
none can
clear that
be
the
granted.
lot, whether it's in one area or another, can be developed upon without the impact of wetlands. That's been demonstrated by the application.
okay, all right. Okay, so we have conditions, and we have an application. Does somebody want to make a motion to approve this with the conditions that we're just gone over with Matt?
I'd be happy to move to approve case number 2020-05, tax map 148-015, with the 7 conditions as proposed by the planner.
Okay, thank you. Motion has been made. How about a second from someone?
I'll second that.
Motion has been made and seconded. All in favor, please say aye.
Aye.
Opposed? Okay. Folks, thank you very much for your testimony and your patience, and we will move on. I can't find my agenda now. Okay. Is that what those folks were here for? Is that what people were here for? What? Yeah, I'm going to. Okay. The next applications, we have 2 applications, and I'm going to consider these, we can consider these together and vote on them separately. So the first one is case 2020-06. This is a condominium subdivision amendment application, addition of stairway to existing deck, Francis Bridges, Klein Revocable Trust, 7 Point Breeze Road, Unit 29, Tax Map 236-002-029. And case 2020-07, condominium site plan amendment application, addition of stairway to existing deck, Francis Bridges, Klein Revocable Trust, 7 Point Breeze Road, Unit 29, Tax Map 236-002-029. And Mr. Applicant, we're going to hear both of these together.
Yes.
They're very straightforward, and then we'll vote on them separately.
Hopefully more straightforward than the previous
Yes.
application. Yes.
Thank you for your patience.
Well, thank you. I tried to get a lot of it cleared up ahead of time, but you saw what the story was. In this particular case, I think some of the members that have been on the board for a while have seen a couple of these at Point Breeze. Again, Randy Tatro for the applicant. When Mrs. Klein called me, she was wrestling with the concept of the steps in the deck off her, the steps accessing off her porch, because the only way she can get onto the deck now is through the house. So she had the option of making the steps inside the deck, which she wouldn't have had to go through any of this to do. Not only the town portion or recording the condo version of it. Just for your, so, but she really wants to have the extra, so she went to the condominium association, got approval first. The confusing part of this sometimes with 356B is whether or not you go under subdivision application, because it technically is a subdivision, because the steps in the deck, the steps in the landing to the deck are in common land, which is owned by a bunch of people under the condominium association rules. So nowadays, like you saw with Harriman Hill and some of the other more modern condominiums, they do a land parcel unit around them, and then within that land parcel unit, they can do things like this without it affecting the condominium. And that's all in the condominium law, in their condominium rules. It's all spelled out in there. But this was one that was done, I want to say, back in
Mid-'80s.
1980s.
So it was set up before they did a lot of that. So the buildings are the condominium, not the land parcel unit around them. So consequently, that's the reason we're here. So because of the fact that we're encroaching out into the common space, that's the subdivision aspect, and Matt can correct me if I'm wrong, and because we're actually doing construction as minimal as what it is, it goes under the site review section, Kathy. So in this case, I think you guys got copies of her, I assume you guys.
Yeah, yes, we do. Yes, we did. Thank you.
So that's it. In the plans, there's an overall version that, there's an overall inset that kind of shows you, that's what I was just showing Roger, where this sits on the total Point Breeze site. So we're in this area right here. If you come off of Pleasant Valley Road and you go down to the first cluster of houses, this unit would be the first cluster on the right next to the main thoroughfare. And in these situations, one of the other reasons that the town, and when Mr. Hausman was here before, the town has the option to, whether or not to have this under their regulations to review. And because the older condominiums developments were approved prior to, like, the wetlands ordinance or any other building setbacks, one of the things that we have to look at in these cases is to make sure, we did one for Sandy Wing further down, and there was a brook, and we had to make sure that what she was doing met the wetlands ordinance. So those are the reasons why we got to go through this process, and we get paid to do it, but it's a lot for her to put up a set of steps. So anyway, this is the area that she wants to do that. There's no wetlands or setback issues. She has requested that we file the condo plan with the registry, should you guys approve it, which is part of it, so it goes on record. A lot of times, people do this stuff and it doesn't get put on there, but technically, the rest of the owners are part of that title. So, without being any more long-winded, that'd be fine. Any questions?
Questions, folks? No. Matt, did you have
I just
any?
have one. Randy, do you have the letter of authorization?
From the condo?
Yeah, I didn't have that in the file. I know you have it. I just wanted to grab a copy of it. If not,
Okay. Yeah, okay, Matt, I know I've asked you this question before. Is there any way of making this process less onerous? I mean, we're really tied into the RSAs. Is that correct?
that is correct. I think I would want to do some research on that, but I'm pretty sure we are committed to making it a subdivision
Yeah,
review
right.
process. I don't think there's...
Yeah, not to interrupt, but she would have to do the majority of this work, Kathy, just to get the condo plan filed at the
Yeah,
registry.
okay.
Your part, you guys' part in it is, for some reason, it didn't meet a setback or a wetlands buffer thing or whatever. It's
Yeah,
really, those are the things that we look at in these
Yeah,
situations.
okay.
Unfortunately, the problem is with 356B and not with our ordinance.
Yeah.
And as Randy said, I think more than 50% of these types of plans don't get recorded and don't go through this process, and owners don't know any better.
A
and
much
they
bigger stage than this. We've had whole
Oh, yeah,
buildings.
and they find out at a later time. So
Right.
although it is onerous, it's the best for the property.
It's required. Oh, okay,
Some
well,
sharp
that's why I
title
just...
person will pick up on it, and it will cause a problem, you know.
Let's move this one
Okay,
along.
yep, then, no, we are going to move it along. Any other, yes. We need to accept these applications as complete. Somebody want to make a motion? All in favor, please say aye. Aye. Opposed? Okay, any member of the public want to speak to this? Mr. Sims, did you want to speak to this? Okay, all right. Matt, did you have some conditions?
I do. I have conditions, and I would recommend separate votes on these, but conditions
Yes.
for the site plan application, conditions 1 through 4, incorporation of the plans as presented. Condition 2, submission of and actually, I made a mistake there. That condition 2 should actually be with the subdivision. So condition 2 is actually all of the documentation submitted in the application package by the applicant is incorporated. So again, for the site plan element, which is case 6, there are only 2 conditions of approval proposed.
Okay, all right, so I'm going to close the public hearing, and any questions? If not, would somebody be willing to make a motion for case 2020-06, which is the subdivision amendment?
That's the site plan number, I'm sorry. So it's 06 is the site plan, just that I put
Oh, okay,
the wrong number of conditions for that.
okay, all right.
We're approving number 6.
Yes,
So moved.
that motion has been made and seconded. All in favor, please say aye. Aye. Opposed? Okay, moving on to case 2020-07.
So case 2020-07, I'd recommend in this one 4 conditions. 1, incorporation of the plans as presented. Condition 2, all the documentation submitted in the application package is incorporated as part of the approval. Condition 3 will be the submission of a Mylar plan to the Carroll County Registry of Deeds for Unit 29. And condition 4 will be the applicant shall be responsible for the payment of all recording fees. Conditions 1 through 4 on the subdivision side of things.
Okay, all right. Any? Okay, motion has been made to,
2020-07.
and want to second that?
Second.
Motion has been made and seconded. All in favor, please say aye. Aye. Opposed? Okay, very good. Thank you very much, Randy. Okay, the next item is the continued public hearing for the design review guidelines, 173-19B. This was a discussion that we had at the last meeting when there was bad weather, and we held the public hearing open in the event anyone wanted to speak to the issue. And I don't see anyone, so I'm going to close the public hearing and would entertain a motion to approve these design review guidelines, which will then appear in our site plan regulations.
So moved.
Seconded.
Okay, a motion has been made and seconded. All in favor, please? Sorry.
Doing so much work on this that
Yes.
I know.
he's not here for the...
I know.
No, that's right,
Yeah, thank you to the committee that put so much into this.
right.
The weather's better, so if anybody had any disagreements,
Yeah.
that they would have been here.
No excuse today. It was 55 degrees today. So.
Yeah. Okay, so all in favor of the motion, please say aye. Aye. Opposed? Okay, this is the opportunity for public comment. Were you here? No, I was looking at Mr. Sims. Oh, I see. Okay. All right, good. Have a good evening.
Thank you.
Guys.
Okay, then, no public comments, action items, I don't see any, no communications or miscellaneous. New business, I just have a quick item. In 3 chapters, it was mentioned that we should add a water quality chapter to our master plan. And the cyanobacteria committee is really revving up and getting going, and so we've been talking a lot about water quality. And I think it would be really a good idea to get going on this chapter. I think it's something that's grabbed people's attention, and, you know, I think we should, so this would sort of support the cyanobacteria issue as well as all water quality issues. But we were
have one
thinking
request.
of hiring yes, put it on the work program, but hire a consultant is what we were thinking of.
I have one request, though. I just thought of this right now. We have a lot of items on our work plan, obviously. Could everyone go home, look at the work plan, and maybe identify your top 5 projects personally that you see on that work plan?
Sure.
And that's just a request, because then we have so much on there, and I want to make sure that we really accomplish the things that are important to the board. So if everyone wouldn't mind just going home, taking a look at the work plan, or even sit down with me and bring back maybe your top 5 of those, it would be really helpful, because I know we want to do this water quality chapter, but we also have a lot of other things we want to do this year as well. I just want to make sure we get those done.
Okay.
Couple of other points under new business. What's going on with the short-term rental subcommittee? When's the next meeting date? Where are the minutes?
You're just rocking and rolling.
Yeah, that's right. We didn't get the minutes to the planning board members. We
sorry.
have the minutes. We will get them to you.
I'm sorry.
Just email them.
I'll send.
I will send them out.
You're going to
Sorry.
send them?
I'll send
Okay,
them out.
Sorry about that.
That'll indicate the next meeting date.
The next meeting date is March 16th at 8 a.m. In the Annex Conference Room.
Okay.
Sorry about that.
Right. And we did have our first meeting, and I think it went quite well. And so we've got our.
Solved all the problems.
No, but we're beginning to.
We actually did discuss many of the problems.
Right.
We're going to have kind of a more open discussion the next time, but when I was doing the minutes, we kind of talked about environmental, code-related, and got a good list of people the committee would like to talk to and some clear pieces of data that they want. So I thought it was a really good start to the process.
One other thing on the master plan implementation memorandum dated 2/5/2020.
Yep.
I have some suggestions and corrections on that.
You're welcome to do that. This is kind of a non-binding memo, but I'm happy to change it.
Well, just a couple of things that I'd like to
Sure.
get covered. In the section, the planning board chair and planning director will,
Yes.
blah, blah, blah. Second from the last, deliver the community facilities chapter to the town manager. Insert and attend a meeting to discuss.
Meeting with who? The planning board?
No, the community facilities chapter delivered to the town manager by the two co-chairs of that chapter, along with the planning board chair and the planning director.
Okay. Okay, does any of the other folks that were involved with chapters want to come along on any of these other meetings? Two chairs.
Maybe we just kind of ask those chairs.
Yeah, I think,
does that
yes,
work?
so I'll do that. Okay, all right, that's good, Mike.
And in
Thanks.
the next bullet point, during delivery meetings, blah, blah, the last sentence, planning board for 2020, change for to in, be correct.
Okay,
And the next one, in February of each following year. And the end of that, a status report for the prior year's goals and recommendation. What does that imply? Are you talking about achievements on the master plan, things that have been done?
Well, or things that have not been done.
Well, that's the same idea.
Yeah, yes.
Okay.
That's what I'd like to do.
Okay. Did you put that into English?
I will attempt to put that into English.
Thank you, that's all I had.
okay, thanks, Mike.
One update, one of the things that the Natural Resources Group wanted to do was to put town properties under easement, which is, I guess, one thing on the town warrant about Whiteface Mountain.
Yep.
And Dan Coons has provided me a list of all the town properties, and Many of them are probably not going to be put under conservation easement because they include things like the town hall. But there are some that we should start contemplating. But he has that list, and it's been created, and we can start working.
Okay, and so basically that's something the Conservation Commission will
Yep.
be, yeah.
Conservation Commission's looking at it, so they're start thinking.
Okay. All right, and are those going to come back to us before, or how is that going to work?
I don't know. I'll have to talk to them.
Yeah, okay. All right. Okay, any other new
couple.
business?
I've got a couple. This is one for Matt. When you go around town and you see work going on and you're the neighbor and you see a bunch of construction going on, you know the guy got a permit, but he doesn't post his permit. Nobody has the permit posted visually as the permits are supposed to be posted. So I'd like to see us make sure that the permits that people get, they post them properly in their locations so that the rest of the people can see that they're doing work and it's approved, yes.
Right.
Yep. And my next one is
You're
to...
talking about the real estate office?
No, I'm just talking about building
district.
permits and so forth, you know, when you
Well, I
go
meant
around.
there's major renovations going on in that office. Is that the one you were thinking of?
No, I was just thinking,
Just
I've
generally.
been around town at a bunch of different places, and you see stuff going on, and
Okay.
you don't know whether or not their deck is legal, or they're too close to the road, or if they're in a
Yeah.
wetland, or what's going on.
Oh,
So
okay, all right.
those are safety factors that are important also.
Mm-hmm.
So I think it's good for the community to see that people are doing this stuff, and when you see a lot of construction going on, you know that they've been to the office.
Right, okay.
And my next one is to get out and vote next week. Make sure everybody does their civic duty. We appreciate it, and thank you very much.
Okay, all right. Anything else before we take a look at the minutes? February 11th.
February 11th.
February
18th?
Man, on page 3, under action items, about halfway down, it says the board and council. That should be COUNSEL.
Thank you.
And the same situation on page 4, the fourth the fourth paragraph where it begins with you. Council needs to be changed.
You're looking at the minutes of
The 11th.
February 11th.
Yeah. And Matt, on the last page, on page 5, where we talk about the work session, I got all panicked because there were a whole bunch of items that were deleted. But when I asked you about it, you said that was just wording that had to be changed.
All right, so I'll look at this. Yeah,
And the wording was that things were done after the master plan. Okay? And so these items were not deleted from our work program.
correct.
Yeah, okay. All right.
I
that
didn't
was
know, yeah.
Yeah, if we could just clarify that.
I can clarify that.
Okay, any other issues?
Also on new business, number 7, last sentence, regarding the facilities director, that was not removed from the community facilities chapter. It is in,
Yes,
it's in twice.
yes, right.
This is always a challenge, though, with statements that are made in meetings that are not correct. It was a statement that was made. You want to just simply remove it? Because we weren't right at the meeting. We thought it had been removed, and then we realized after that it hadn't been. So
So it was
you comfortable just
it was a
remove?
discussion item, and
Right.
Yeah, the trouble is, though, someone's, as we heard tonight, going to go back to the minutes in 5 years' time, wondering about why there is still no community facilities manager, and discover the planning board discussed that it had been removed from the chapter.
So that's why I would say just take this out then,
Could we remove that from the minutes?
rather than,
Yeah, I think
rather than
that-
correct it. because-
Right, is that okay with you, John? Okay.
And February 18?
Well, can we just vote on the, okay,
Move to approve.
okay with the corrections
Actually, I'm sorry, could I go back to the 11th? I just have a question on this item.
on the 11th?
Yeah, just on the last item we talked about. John, you did ask about the status of that position.
I did,
did.
I did.
So I guess, do you want that in there? Because what I would basically, I can amend this to say, you inquired about it and we reported that no, I mean, we did report that no immediate progress had been made. I mean, I could just say that.
That's fine. That's,
Is the board
Why
comfortable?
don't you just write, Matt Sullivan replied, it is a critical issue, period.
Okay, that's fine.
Leave everything else in the middle.
Oh,
I'm okay with that. Sorry,
Yeah,
just because the point is important, I didn't want to.
right.
Move to approve with the amended conditions.
Oh, okay. And somebody second? Motion has been made and seconded. All in favor, please say aye. Aye. Opposed? Okay.
I'll abstain,
Abstained? Oh, yes.
wasn't here.
Okay, the February 18th,
I have just one on page 2,
okay?
Mike Hodder thing.
A Mike Hodder thing,
Yes.
where you questioned,
Mike Hodder suggested inserting 2019 master plan.
okay?
I'd like to have, that was approved by a vote of the board because was indeed done.
It was approved by a vote of the board.
Yeah. Otherwise, it just remains as a suggestion, not acted upon.
Okay, I
Yeah,
okay.
okay, and,
It's in the text that we have
Yeah, that's why I wanted to make sure, yeah, so that was approved, yeah.
okay, and I just had one correction on page 3, on the update on the foundation certification policy. Vaughn questioned the scale should be 120, it's 1:220. I'm
No.
sorry,
So
but
I had
do
I had
read them.
modified a set of these minutes, and then I deleted it from my computer.
Oh.
And then I was trying to remember what changes I had made. That was the change, and so. Thank you.
Okay, somebody want to make a motion to approve these with the corrections? Motion's been made and seconded. All in favor, please say aye. Aye. Opposed? Okay.
I'll abstain again, too.
Okay. All right, folks, we can be adjourned. Do we have anything, next meeting? Basically, work items.
We're gonna have work session items.
Yeah, okay, all right. And everybody's going to come with their top 5 issues.
you talked about in the minutes there, you talked about the subdivision, or the boundary line adjustment at Pleasant Valley, and you were gonna give us a little feedback on that.
I reached out to their council. They want more time.
Okay.
Yeah, it's an issue for them still. So you may not see it ever again, quite honestly. Which,
Shame.
yeah, I don't know, but I did talk to the council and I sent them an email. I'm happy to share the email with the board, but it may not come forward. Because frankly, what I was told is that the cost of removing the structure might be too substantial. Why do they even want to do it? The lot merger that we kind of debated a lot about the structures and everything on it, that one may not move forward, so.
Land is still there.
Yeah, but
I don't know why they want to put them together.
taxation purposes.
People, they're paying taxes.
Are you adjourned? Are you adjourned?
Yes, yes, we were adjourned and then we, sorry.
So make sure, I don't want to stop.